Okay, let's get into this. We're doing a deep dive today into, well, a pretty tough situation.
Yeah, it really is. We're looking at what's happening with the folks holding loan notes in the 79th group.
Exactly. Now that several of their companies have gone into administration.
And you shared some interesting source material, including a guide someone sent in. It really tries to break down what administration means for these loan note holders specifically.
That's the one. So our aim today really is to unpack all of this. We need to understand the process itself, figure out who the key players are, what maybe the biggest hurdles might be.
And most importantly, what this source material says this means for you, the investors who are actually in this situation.
Yeah, because the material points out some things that, frankly, might be a bit surprising.
Like, who gets their money first? It's not always who you think.
Right, and concerns raised about the actual people in charge now, the administrators?
And even some data protection stuff flagged in there, too. Worrying.
It's definitely complex, so let's just dive straight in. Based on that source material, what actually is administration in this specific context?
Okay, so the document defines it as a formal UK legal thing.
Yeah.
It happens when a company just can't pay its debts. It's insolvent.
Right.
The idea is, supposedly, to protect creditors. Meanwhile, these licensed professionals try to either, rescue the company.
Which sounds rare.
Often is, yeah. Or, more commonly, they sell off the company's assets to try and get some cash back.
So the original directors, the people running the 79th group companies before this, they're out.
Completely sidelined, yes.
Yeah.
The moment administration starts, the source says, company directors lose control.
Okay.
And these licensed insolvency practitioners, the administrators, they get appointed and take over all the management decisions.
So their whole focus shifts.
Entirely. Their job now is purely about recovering value, finding assets, and getting money back to the creditors. That's the goal.
Okay, they're focused on recovery. But you mentioned something critical earlier, who gets paid first?
Yes, and this is a really key point the material hammers home. Before any money goes to investors, or even other general creditors, the professionals involved in running the administration, that's the administrators themselves, their lawyers, maybe forensic accountants, anyone they hire.
Okay.
Their costs and fees have to be paid first. In full.
Wow.
And the source is blunt. Every single pound they charge in fees is a pound that isn't available to potentially return to you, the investors.
That's stark. Okay, so who are these administrators? The material names, specific people and firms, right?
It does. It lists who's been appointed for the different 79th group companies now in administration.
Okay.
So for companies like 79th Luxury Living 5, they call it LL5, and 79th Commercial 3 or CM3.
Yeah.
The administrators listed are Andrew Stoneman and Robert Goodhue from a firm called Kroll Advisory.
Kroll, okay.
And also Jeremy Woodside from another firm, Quantuma, is listed for those same two companies.
So multiple firms involved there. What about the others?
For 79th Luxury Living 6, LL6, the source names Gareth Latimer and Stephen Cave. They're from Grant Thornton.
Grant Thornton, got it.
Yeah.
Any others mentioned?
It also notes that Kroll is using Crowell and Mooring solicitors for legal advice on the LL5 and CM3 administrations.
So it really sounds like if you're a loan note holder in this, you are now completely dependent on these specific individuals and firms.
That is exactly the situation the material describes. It stresses that your potential outcome now rests entirely with them.
It depends on how they handle it.
Yeah. How fairly they run things, how good they are at actually recovering assets, and crucially, how well they control their own costs. Because, again, those costs come right off the top.
Okay, administrators are in place, they've got a job to do. But what are the big challenges in actually getting that money back, recovering assets? What does the source say about that?
Well, the guide suggests they usually start with the, let's call it the low-hanging fruit.
Makes sense, like what?
Any cash the company might have had sitting in bank accounts, money owed to the company accounts receivable, or maybe physical property that can be sold relatively easily.
Okay, the more straightforward stuff. What about more complex things, like if money needs to be chased through legal action, lawsuits?
That's definitely on the table, and the source material mentions litigation. But it flags some really big ifs.
Such as?
Pursuing a legal claim, it says, only really makes sense if, 1, the party you're suing actually has assets to pay up if you win.
Right. No point suing someone with empty pockets.
Exactly. 2, you need strong evidence for your claim. And 3, this is a big one. The estimated legal costs can't be more than what you might realistically recover.
So it's a cost-benefit analysis even for chasing money owed?
Precisely. The source points out if you spend, say, £100,000 on legal fees to chase a claim that only brings back £80,000, well, that's just lost money.
And that loss ultimately hits the loan note holders again.
Yes, because it further reduces the pot available for distribution.
This really leads to a fundamental question the material raises. Can investors, trust this whole administration process, trust the administrators, given the costs and complexities?
Yeah, this is where the document brings in some quite pointed considerations. It basically says, look, Kroll, Grant Thornton, Quantuma, they are now the gatekeepers.
They control the outcome.
Pretty much.
Yeah.
Their track record in previous cases, how tightly they manage costs in this specific administration, and how transparent they are, all of that directly impacts what, if anything, investors might get back.
And the source suggests investors shouldn't just sit back, they should ask questions.
Absolutely. It suggests it's perfectly reasonable for you, as a loan note holder, to ask things like, have these specific administrators actually managed to return money to creditors in similar situations before?
Okay.
What are their charge-out rates? How much per hour? Have these firms worked together before on something like this?
Right, their working relationship.
And significantly, have any of these administrators or their firms faced disciplinary action from regulators?
Regulatory issues. Now, the document does mention a specific instance, doesn't it?
It does, yeah. It specifically highlights Gareth Latimer. He's one of the Grant Thornton administrators appointed for LL6.
What does it say about him?
The material states that in 2024, he was actually fined by the UK's Insolvency Service.
Fined? For what?
For breaching the Insolvency Code of Ethics. The specific breach mentioned was failing to keep client money, or estate money, company money, separate from other funds.
That sounds not good.
The source describes it as a serious violation, yeah.
And what about his firm, Grant Thornton? Anything mentioned there?
The document adds that Grant Thornton itself has also faced sanctions from regulators in the past related to audit and ethics standards.
I see.
And the guide uses these examples really to underline why creditors might feel concerned and why things like oversight or maybe getting independent support could be important.
Okay, let's switch focus slightly. There was another concerning point in the material, wasn't there, about data protection?
Yes, this was another area flagged as worrying. The source indicates that some 79th Group loan note holders have apparently been getting unsolicited emails.
Unsolicited emails from who?
From third parties. And it actually names one specific entity as an example, Bond Review or Safe or Scam.
Bond Review or Safe or Scam. Okay. And what's the concern there?
The concern, according to the source, is that this outfit, which it describes as being based overseas and unregulated in the UK, seems to have somehow got hold of personal and financial details about 79th Group investors.
How would they get that?
That's the big question. The document notes these emails often mention a UK law firm, raising serious questions about how the data was obtained and, whether data protection laws might have been broken in the process.
So if you, as an investor, get one of these emails, what does the material suggest you do? Or what are your rights?
It makes it clear you absolutely have rights about your data. The advice in the source is ask them directly.
Ask the sender.
Yes. Ask them. Where specifically did you get my personal information from? Ask.
Yeah.
Are you actually regulated to provide services in the UK? And critically, do you genuinely represent my interests?
Good questions.
And the source also points out that if you suspect your data has been misused, you have the right to complain to the Information Commissioner's Office, the ICO.
Okay, good to know. So we've talked process, players, problems, data concerns. What happens next in the actual administration timeline, according to this guide?
Right, so there are some key steps administrators have to take fairly quickly. The guide says they have to prepare and send out 2 really important documents.
When?
Within 8 weeks of the administration starting, so quite soon after appointment.
And what are these documents?
Okay, first is what's called a statement of affairs. Think of it like a financial snapshot of the company right at the point it went into administration. Assets, liabilities, etc.
Okay, a snapshot. And the second?
The second is the administrator's proposals. This is where they're meant to lay out their actual plan.
Their plan
for how they intend to manage the company's affairs, how they plan to recover assets, and ultimately how they propose to distribute any money they manage to get back, if any.
Right. So those documents should give some clarity. How long does this whole administration process usually last?
Well, the standard initial period is supposed to be 12 months.
A year?
Yes. However, the source material is quick to point out that administrations are very, very often extended, sometimes multiple times.
And I guess extensions mean more?
More fees, exactly. Each extension usually means more professional time being billed.
Which comes out of the pot again.
Correct. The material notes that these extensions, while sometimes necessary, inevitably eat further into any funds that might otherwise have been available for creditors. It can significantly reduce or even wipe out potential returns.
Okay, so putting this all together, the complexity, the priority of fees, the potential for delays and extensions, the recovery challenges, what's the realistic risk here for the loan note holders, based on this source and similar situations?
The document is pretty blunt, honestly. It points out that in many similar cases, complex investments, insolvency practitioners involved, even when assets are successfully recovered and sold, the professional fees charged for doing that work can end up consuming most, or sometimes all, of the money raised.
Leaving little or nothing for
the unsecured creditors.
Yeah.
And that's usually where loan note holders sit in the pecking order. So very little, or often nothing, is left for them.
And the source suggests that's a real possibility in this 79th group situation.
It explicitly states that this outcome could happen here too. It really hammers home that whether you as a loan note holder see any money back depends completely on two things: how much the administrators successfully recover and how high their costs are in doing so.
It sounds quite passive from the investor's point of view, just waiting to see what happens. Does the material suggest any proactive steps investors could take?
Yes, it does touch on that. It sort of implies that just relying on the standard administration process might not be the best strategy for protecting your own interests.
Right.
Because, as it notes, the process isn't primarily set up to prioritize individual investors first. It suggests that taking action earlier, being more proactive, generally puts you in a better position.
And it mentioned a specific group, Insolvency and Law, didn't it, saying how they were helping investors?
It did, yes. The source material describes Insolvency and Law as pursuing what it calls a more proactive route for loan note holders, rather than just passively waiting for the administrator's process to play out.
Okay. And what kind of proactive things does it say they're doing?
According to the document, it details a few specific actions. First, it says they helped investors file winding-up petitions against some key 79th Group companies.
And what did that achieve?
The source states this action helped to actually trigger the formal administration process, pushing things forward when they might have stalled.
Okay, what else?
Second, it says they are actively investigating the regulated financial advisors, the promoters, the introducers, who were involved in selling these loan notes in the first place.
Why investigate them?
The angle there, according to the source, is that some of these regulated firms might have breached their duties to investors. And, crucially, many of them might have professional indemnity insurance.
Insurance that could potentially pay out compensation.
Exactly. That's presented as a potential route for recovery, separate from the administration itself. And third, the document mentions they're providing claims support.
Meaning?
Helping loan note holders understand their legal rights, reviewing the specific loan agreements they signed, and assisting them in formally lodging their claims within the administration process. And just to be clear, all this is based directly on what's stated in the source material provided to us.
Understood. Okay, so let's try and summarize based on this deep dive into the source material. Administration for these 79th Group companies is clearly a complicated and potentially very expensive legal path.
Definitely complex, and the costs are a major factor.
Right. Professional fees get paid before investors see a penny. The actual amount recovered for loan note holders looks pretty uncertain, heavily dependent on what assets are found and how efficiently the administrators work.
And how much it costs them to do it. Yeah.
Plus, we've seen the material raises flags about potential oversight issues with the administrators themselves and these quite concerning reports about investor data being shared inappropriately.
It paints a picture of a very challenging and uncertain road ahead for these investors, no doubt about it. Lots of moving parts, lots of risks.
So here's maybe a final thought to leave folks with, prompted by this material. When you see how these processes work and how, as the source highlights, the professional fees can potentially consume so much or even all of the recovered money, what does that really tell us about the fundamental design of insolvency procedures like administration? Are they truly set up primarily to rescue businesses? Or are they more about an orderly, albeit expensive, sell-off of assets after things have gone wrong?
It's a fair question.
And considering who bears the costs versus who gets paid first,
Yeah.
who ultimately stands to benefit the most when a company fails and enters this kind of formal process, something to really think about.